Hello, my name is Yoshi Bauer. Welcome to the My Special Needs Connection webinar and podcast series. As a parent of children with special needs and as a professional advocate, I understand the challenge of connecting parents and professionals with the information that they need to serve children and adults with special needs. At My Special Needs Connection, we empower parents and professionals through valuable instruction and insights of experts in the special needs community. We're excited to come alongside you to provide you with information that you need. Let's grow through the exchange of knowledge and the hope of success. Be sure to subscribe to our newsletter and YouTube channel for new releases. Please enjoy our webinars and podcasts.
Well, I want to welcome you to this webinar. You know, as schools are reopening, we're seeing some unique circumstances. Schools are doing things a little bit differently, district to district and school to school, in terms of their reopening and how many days they're reopening, what the classrooms look like. But one concern that has come to me is a school district that has a policy of excluding children who can't tolerate masks from the classroom. And in this particular school district, it's done through what's called an IHSP, or an individual health and safety plan. And essentially this plan, which is pretty much across the board for all children who can't tolerate masks, it says that if a child can't tolerate a mask, they're allowed to come back to school, but they have to be educated outside. They have to be educated outside of the classroom where all their peers are located. They're either educated outside by themselves, or maybe there's a peer that rotates in and out from the classroom, but they're basically isolated and separated from their peers completely. The other thing that the plan has dictated is that if the child has to go inside the classroom for any reason, then there is a classroom available for that child, but they have to be alone. They can't have any other peers in the classroom. And they're educated either through an aide or through a teacher, but again, educated by themselves. So this has created obviously problems for parents who are concerned that their children are going to be isolated. They're being educated outside. What if it rains? What if it's hot? What if it's cold? What if their child elopes? What if their child wants to come into the classroom and follow their peers? All of these issues are very concerning. So the question becomes, is this legal? Is it compliant with what's called the IDEA, or the Individuals with Disabilities in Education Act? And that's the special education law that dictates the rules regarding special education program. It's the federal law. And this law was written in the mid-70s. And one of the main components of this law was called the least restrictive environment, or the LRE. And essentially what this principle says is that children with disabilities are supposed to be educated to the maximum extent appropriate with their non-disabled peers. The law built in this integration. And the reason was that historically, before this law came into existence in the mid-70s, children with disabilities were isolated from their regular education peers. They were sent to separate schools. They weren't allowed to mix with regular education students. And in fact, some special education students, unfortunately, weren't even allowed an education at all. So in the mid-70s, when Congress created this law, that was a major component, was this principle of least restrictive environment. And if you look at this policy where these children are being isolated, separated from even their not only non-disabled peers, but disabled peers as well, being isolated outside or in a classroom just by themselves, one obviously would question whether this complies with the LRE. So the next question is, is there some federal state guideline that mandates that children who can't tolerate masks because of their disabilities have to be excluded in this manner? But if you look at the CDC guidelines, there is no such mandate or requirement. In fact, the CDC guidelines state that if a child can't tolerate a mask because of their disability, they're not required to wear one. And if you look at the California Department of Education guidelines, it essentially says the same thing. In fact, it goes a little bit further. If I could share a PowerPoint on that issue, it essentially says what what I just said, which is that children who can't tolerate a mask should not wear one, but it goes further. It says that they should not be excluded from educational environments if their disability prevents them from wearing a face covering. And the school district has to comply with the LRE, which is what I just mentioned. So what is the format for this policy? Well, it is in a document called the Individual Health and Safety Plan, or IHSP. And it's a document the district created for basically all children who can't tolerate wearing a mask at school. And it basically is the document that requires the children to be educated outside if they can't tolerate this mask, but can come inside at certain points as long as they're inside without any other children. So based upon the federal law, IDEA and LRE, the CDC guidelines, which don't require children who can't tolerate masks to be excluded, or the CDE policy saying the same thing. In fact, actually encouraging school district to include these same students, don't exclude them from educational environments, comply with the LRE. One certainly would have to question that the district's policy is not consistent with the law. And there is a principle in the law called preemption, where the federal law supersedes any district policy. So the district can't create a policy that takes away rights of special education students. It can't violate the federal law. So you can draw the conclusion that it is inconsistent with the IDEA. One other topic that I would like to address with respect to this policy, this individual health and safety plan, is predetermination. Now, predetermination occurs when the district creates the IEP before the meeting and it's set in stone. In other words, the document is created outside of the process of the IEP, where all the team members meet, including the parent. And then it's brought into the IEP as a take it or leave it situation. So the parent isn't allowed to participate. The parent isn't allowed to ask questions, to make comments. There's no ability to revise the document, modify the document, scrap the document. It's a take it or leave it. The district can bring into the IEP a draft IEP, as long as it's not set in stone. So in other words, they can have an IEP document, bring it into the IEP, and everybody can look at it and make comments, as long as it's a flexible document where the parent can have input, can ask questions, can make suggestions. Revisions are available, and the district is able to do that, and can show that they operated in good faith and listening to the parent, and had the ability to change the document as was appropriate. But if that document comes into the IEP and it's subject to no negotiation, no participation, no revision, then certainly predetermination is an issue. I'd also like to address the concept of parental participation. And what that is under the law, the parent is deemed to be an equal participant in the IEP process. I like to tell parents that their participation is just as meaningful and just as important as anybody else sitting at that table. So Congress understood that the parent has, unique information about the child. While it's true the district sees the child during the school day and has a lot of information about their education, the parent has a lot of information about the child outside of the school day, and obviously has spent a whole lot more time with the child over the years, and can have a lot of insight in how the child, learns, what motivates them, what makes them upset, etc. So Congress wrote that into the law, that the parent has this right to participate, to get notice of the IEP meetings, to attend the IEP meetings, to give input, to ask questions, to offer advice, to offer their own assessments for discussion. But in a situation such as this, where this document is brought in and basically the parent's told, we can't change it, it's our district policy. No, you can't make suggestions about social distancing as an alternative accommodation, or ventilation, or plexiglass, or dividers, or anything else, then they're not getting the opportunity to participate. If their questions aren't answered about what if it's hot outside, what if it's cold outside, what if the wind is blowing and it's raining, what do we do then? What if my child lines up with the other students to go into the classroom, and when my child is told they can't go in the classroom, they run into the classroom, then what happens? Or what if my child elopes? My child's outside and sees some kids playing with the ball and runs out after them. What happens then? So those are the kind of things that I think lend themselves, unfortunately, to a situation where predetermination occurs and the parent isn't given the opportunity to really fully participate in this meeting. So I'd like to conclude with just some suggestions of what to do if you as a parent are in a school district that has a similar policy. He has an individual health and safety plan, and you have an IEP meeting upcoming, and the writing's on the wall that they're going to ask you to sign this plan, or your child can't come back to the school setting. Well, first of all, I think it's important to tape record the meeting. The way you do that is to give written notice at least 24 hours before the meeting. In the state of California, you can do that, and it's your legal right to record the meeting. You don't need permission, you just have to give the notice. And I think this is really important because there's going to be a lot of discussion going on during the meeting. You're going to have questions. You're going to ask about this plan. Can we consider alternative modifications? You can make suggestions about social distancing, dividers, plexiglass, ventilation, so on and so forth. You can ask the questions about what if it rains, what if it's too hot, what if my child tries to elope. If you don't get those answers, then that needs to be documented. And all of that information is not going to be written into an IEP. Having that tape going with all your questions and all the responses is going to be really important. I would also, if you aren't successful in getting the answers you need, and this plan is take it or leave it, you might consider either not signing the IEP or signing the IEP except for this individual health and safety plan. So you can sign an IEP and say, I agree with all components of the IEP except for. So you can make a notation that you're in agreement with the IEP except for the individual health and safety plan. And there's usually also a box at the end that notifies whether the parent had the opportunity to participate or not. And I wouldn't check that box if what I've described happened, because then obviously you would not have had that ability to ask those questions and get the information that you needed through the IEP process. If you're not successful, you might want to just send an email as kind of a final attempt to resolve the matter. Send it to the case manager, the director of special education, as to what happened. It was a take it or leave it health plan. You want your child back in school, but you don't want your child isolated, and that this policy is not in compliance with the IDEA. If that's not successful, then there's always due process. Special education attorneys can file for due process on the issues that I've mentioned. Might be a good idea to have an advocate go with you to that IEP that I mentioned, help you navigate through this process. But if you're not successful, then due process might be the only option available. And that's what special education lawyers can do for you. So I hope this webinar was helpful. Hopefully you won't get in that unfortunate situation where your child is only option to coming back to school is to be isolated. But again, there are steps that you can take to hopefully avoid that, following some of these recommendations. And worst comes to worst, there is always the remedy of due process to challenge the school district in a policy that may not be consistent with state and federal laws. So I want to thank you for attending.